Mr. Lewis, you have Crystal Vogan, this is sentencing. Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower. Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes. Yeah.
And any additions or corrections or?
There's a lot of history, we understand, Your Honor, but discussed it with counsel and also restitution.
Speak up, I'm sorry.
I just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
Right.
All right, buckle up, because today's video is going to be a roller coaster through the legal system. We got not one, but 2 jaw-dropping cases to unpack. And trust me, the drama levels are off the charts. First, we head to Texas, where a woman with rap sheet longer than most people's resumes thinks she's walking away with a sweetheart plea deal. But when her mouth runs faster than her brain in front of a no-nonsense judge, let's just say things go downhill fast. Then we'll jump to Florida, where a man decides he's smarter than trained lawyers and tries to represent himself.
Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, you know, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was
the 400 that was within the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the other status of another person, Your Honor, that's just one that's the charge. I'm not there to coach them on there. But she's responsible.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's okay. Apparently the cops didn't either. So
She went in the bank, she was the one called. Size, whether or not she has a company. The backside is not to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward?
Notice how the judge is taking her time to read through every single conviction, and probation? That's not just to embarrass her. It's to establish a clear record on the court transcript. Judges often do this so that if the defendant tries to appeal later, it's crystal clear that their history was considered before making a ruling. And let's be real, 14 felonies plus multiple misdemeanors is not a youthful mistake situation. This is a career criminal resume. Question for you guys. Do you think someone with this kind of background deserves another chance with probation, or should the judge finally put her foot down?
Potentially it have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay, how many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggregated theft in Ohio.
Now, here's where things get interesting. She claims she's working toward nursing school, while standing in court with a mountain of financial crimes, thefts, and even human smuggling convictions behind her. That's not just irony, that's delusion. Nursing programs require extensive background checks, and criminal records like hers almost always block certification. It raises a bigger question. How often do people facing sentencing exaggerate their future plans to look good in front of a judge? Drop a comment. Do you think the judge is buying this nursing school story or rolling her eyes internally?
It don't matter, my life's on anyway.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
He said, you're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
This moment right here is critical. Judges don't have to accept plea deals. The prosecution and defense can agree on terms, but at the end of the day, the judge is the gatekeeper. And when a judge openly admits she's struggling to even consider the deal, that's a massive red flag. It means she sees probation, especially deferred probation, as an injustice to the community, given this woman's track record. Think of it this way. If someone with 14 prior felonies can walk away clean after probation, what message does that send to every other defendant in the system?
Yourself.
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request to have my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why?
If you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up a fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker. But however, you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Well, can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and that I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on
And here's the bombshell. 5 separate convictions for human smuggling. Not petty theft. Not just financial forgery. We're talking organized smuggling of people for profit. This is why the judge is incredulous about the plea deal. It's not just about restitution to the bank. It's about the bigger picture of public safety. At this point, the defense attorney's hands are tied. There's no convincing a judge that someone with drug charges, forgery, theft, and human trafficking belongs on deferred probation. Honestly, it's shocking the prosecution even offered it in the first place. And there it is, the meltdown. Instead of staying calm and letting her lawyer try to salvage the deal, she starts swearing at him in open court. That's like spitting in the referee's face while they're deciding on your penalty. Judges notice attitude as much as history. And here she basically handed the judge an excuse to revoke bond. This is courtroom sabotage 101. When you can't control your temper, you dig your own grave. Be honest. Do you think she just cost herself years of freedom by lashing out, or was the judge already done with her?
all the thing I'm asking, sir, is why am I being denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case,
Okay.
and they were only being assisted
I've
by.
heard this argument for the last, ever since you've been arrested, so it's already part of the record. I've already made my ruling. You've already appealed that ruling, so we'll see what the first DCA says. I'm gonna set this for a pretrial June 19th at 9 o'clock. That'll conclude the hearing. Okay?
Well, sir, I still had a couple things I really wanted to say for the record.
Say them on the 19th.
Seriously, come on, Ms. Clark, man, we got.
What do you want to put on the record? I'm gonna give you a minute. Go.
All right, whole thing I want to put on the record, Ms. Clark, is I don't know what kind of beef that you got with me, sir, or Mr. Frank Sullivan, but I keep having multiple prosecutors filing motions against me, the ones that was pulled off of my case. Why they still filing motions
Mr.
against me?
McCoy, I understand that argument.
But it makes no sense because it seems like my case is going nowhere,
Listen,
especially when you have nothing to even
These
try
state
to do.
attorneys don't stay here very long. The ones that are on your case are in another division. I have nothing to do with that. Mr. Sullivan has nothing to do with that.
You know, he just said he does.
Huh?
He just said he did. Though.
No, what I said, Mr. McCoy said that despite who the prosecutor is, you're also involved in my case. And I said, yes, that is true because I'm the division chief.
He's
I didn't say I had anything to do with moving prosecutors or changing.
he doesn't move property. He is the division chief, so
Okay, if
request.
my old prosecutors already moved to a different
division, whatever, why is she still filing motions against me? And then obviously when she signed it, she said this motion is for Frank Sullivan.
They all sign it for Larry Bassford. It doesn't matter who signs it, who files it. They were filing on behalf of Larry Bassford. So that's going to conclude today's hearing.
That makes
Y'all
no
go ahead
sense,
and
Mr. Clark.
Mr. McCoy, that concludes the hearing. I understand. There's nothing else to be said about that.
Now we shift gears to Florida and meet Mr. McCoy, a man whose decided lawyers are optional. He's representing himself, also known as pro se. Judges usually warn defendants that this is a terrible idea, but legally, they can't stop them. Here's the problem. McCoy doesn't understand court procedure. He keeps asking the judge for explanations and even advice, which judges are legally barred from giving. It creates this endless cycle where the defendant feels unheard, and the court gets frustrated. This is why 99% of pro se defendants crash and burn, because court isn't about who argues the loudest. It's about who knows the rule. And there you have it, two wildly different cases with one common thread. Defendants who couldn't get out of their own way. In Texas, we saw a judge slam the brakes on a plea deal after reviewing a staggering criminal history, and a defendant who sealed her fate with bad attitude. In Florida, we watched a man try to play lawyer against the system, only to run face first into legal walls. These cases remind us that in court, history and behavior matter just as much as the charges on paper. So now, I want to hear from you. Do you think the Texas judge was too harsh or absolutely right to reject probation?